Authority Saturn 3 WPC 5781 of 2016, along with item 4 to 7.
First, I'll finish. Only two more judgments I'll rely because too much emphasis has been given that they were not provided with the personal hearing and the opportunity of personal hearing was missed. So, in these circumstances, first, my submission would be that he never sought for any personal hearing. Second is, you Lordship may kindly take up the compilation which I have given. There are two more judgments directly on this issue. The two judgments are 2001 volume 8 SCC 604. In this, there are two Supreme Court judgments. In both these cases, extreme step of blacklisting order was passed by the government in exercise of contractual contract, and then the matter was challenged, and what the Honorable Court holds in this. Your Lordship may kindly take up first one, that is 2001 volume 8 SCC. Page 46, page running page.
Yes.
Your Lordship may, first paragraph, what was the fact? In first paragraph we have highlighted, under such circumstances, the state government served a notice on the appellant to show cause why it should not be blacklisted in its dealing with the government. It appears that the appellant sent a reply to the show cause notice. The state government, on expiry of the period for reply by the appellant, passed an order of blacklisting the appellant. The order indicated the period of blacklisting will be till the disposal of the case so and so. And then the appellant challenged the aforesaid order by means of a writ petition under Article 226 of the Constitution of India. The said writ petition was dismissed. Agreed, the appellant has challenged the said order and judgment by way of special assembly. Then, para 2, Your Lordship, after 4-5 lines, we do not find any merit in this contention. Admittedly, the appellant has only contractual relationship with the state government, and the said relationship is not governed by any statutory rules. There is no statutory rule which requires that an approved contractor cannot be blacklisted without giving an opportunity of show cause. It is true that an order of blacklisting an approved contractor results in civil consequences, and in such a situation, in the absence of statutory rules, the only requirement of law while passing such an order was to observe principles of body altering party, which is one of the facets of principles of natural justice. The contention that it was incumbent upon the respondent to have supplied the materials on the basis of which charges against the appellant was based was not the requirement of the principle of body altering party. It was sufficient requirement of law that an opportunity of show cause was given to the appellant before it was blacklisted. It is not disputed that in the present case, the appellant was given an opportunity to show cause, and it did reply to the show cause, which was duly considered by the state government. We are therefore of the view that the procedure adopted by the respondent by blacklisting the appellant was in conformity with the principles of natural justice. So absolutely identical circumstances here also. In our case, where show cause notice was given, they replied, it was considered and order was passed. Then the second judgment, 2012 volume 11 SCC, page 257, Patel Engineering Limited versus Union of India. And in this case, Your Lordship, again identical circumstances were there. Paragraph 5, respondent number 2 issued a show cause notice on so and so, calling upon the petitioner to explain as to why action debarring blacklisting the company for a period of 5 years from participating or bidding for future projects to be undertaken R2 should not be taken. On 1/3/2011, the petitioner replied to the show cause notice. 2 months later, R2, through its letter dated so and so, communicated the order that barred the petitioner from pre-qualification and participating or bidding for future projects undertaken. Then paragraph 7, a division bench of the High Court upheld the order and dismissed so hence the SLP. Now, Your Lordship may kindly see para 9. The learned counsel also submitted that assuming for the sake of argument that it is legally permissible to blacklist the petitioner on the ground that it declined to enter into a valid contract after it had been declared a successful bidder by the second respondent, such a decision is required to be taken only after complete compliance with the requirement of principles of body alternate pattern, and the petitioner should have been given an oral hearing before the impugned decision was taken. Now, answering this, the Honorable Court says in paragraph 38, coming to the submission of R2, submission that R2 ought to have given an oral hearing before the impugned order was taken, we agree with the conclusion of the High Court that there is no inviolable rule that a personal hearing of the affected party must precede every decision of the state. The court in so and so held that even in the context of quasi-judicial decision, we cannot therefore take a different opinion in the context of a commercial decision of the state. The petitioner was given a reasonable opportunity to explain its case before the impugned decision was taken. We therefore do see no reason and so on. So therefore, absolutely no requirement of law or any rule that he has to be given personal hearing. And he did not even ask for in any of the after giving a show cause, he did not ask for any personal hearing.
That's it.
This is
The last point I will be replying first. The two judgments not just now cited by the respondent, 2001 8 SEC 604 and 2012 11 SEC 257. Lord, admittedly, the Honorable Supreme Court, while dealing with these matters, has come to a conclusion that it was a civil consequence. But my case is that it is a criminal consequence of it. So these judgments will not apply in my humble submission on the facts of the case. Now, to the extent of personal hearing, I have not pleaded and things like that have been submitted. Lord, it is a settled principle, my Lord, that what the legislature could not do, the executive also cannot. Now, while, my Lord, enacting the Essential Commodities Maintenance Act 1955, there is a prescription of personal hearing. And
For imposing a criminal liability.
for imposing a criminal liability in the nature of fine. If my Lord may kindly see section 53 of the IPC, that fine is one of the punishment under IPC. So, my Lord, if a fine is to be imposed and a procedure is prescribed under the 1955 Act, my Lord, they cannot have a right to circumvent the due process of law.
1955 Act provides for fine also.
Yes, it provides for fine, imprisonment.
Let us see the fine.
I'm sorry, woman.
Let us see the fine. Let us see the fine.
In the 1955 Act. Yes.
And shall also be liable to fine. Punishment and fine both.
Right.
7 years.
Right. And
Minimum
section 12.
sentence is also provided.
Yes, section 12 also, my Lord, may kindly take note of. Special provision regarding fine. The power of the magistrate is not limited to 5,000 under CRPC. It has been, my Lord, extended beyond 5,000 rupees. My Lord, it has come from the Honorable Court that the fine is relatable to the quantum of irregularity. My Lord, there are in the marketing discipline guidelines, my Lord, there are slabs. For an irregularity of 1 cylinder, maybe, my Lord, the fine is same as maybe for the irregularity of 10 cylinder or 50 cylinder. The slabs are vast enough. It is not commensurate to the irregularity. They have given it under a slab. And, my Lord, the judgment of the Honorable Supreme Court, which was relied upon by the respondent 2019 SEC, if my Lord may kindly see for a moment paragraph 15 of that judgment.
19.
2019 volume 19 SEC,
You
page
have placed
662.
it.
This was placed by the respondent. Lord, here the case was that the
Para number?
para 15. the distributor was proceeding on both the premises that MDG has to go along with the Act of 1955 and then CRPC has to be observed. But at para 15 there is a specific finding of the Honorable Supreme Court in the second line. It is not disputed that the dealer is bound by the guidelines issued by the public sector oil marketing companies. So, my lord, the entire case proceeded on this premise. Here, my lord, the MDG is disputed. So, this judgment, my lord, will not apply in the facts and circumstances of this case. Because a little difference in facts, my lord, has a vast difference on the precedential value of this order. And, my lord, so far as the MDG guidelines of 2015, which was read, my lord, the preamble or the foreword to it, my lord, it has been attempted to indicate that it is a very beneficial kind of an action being undertaken for the interest of the consumers. Well, the interest of the consumers are paramount, but then the rights of the distributors cannot be subjugated to their whims and fancies. Because in the 2015 guidelines, my lord, they have become wiser enough to relate it to the faithful performance clause. But prior to that, my lord, if 2001 guidelines, my lord, will see in the writ petition of Tara Enterprises, Annexure 7. There is no such forward to the MDG guidelines.
Sorry?
Lord, the 2001 guidelines.
This faithful obligations is not there.
That is not there in the 2001
Yes,
guidelines.
in 2001 guidelines it is not there.
But the faithful performance is a contractual clause which is in all the agreements.
No, in the MDG.
That is in the contract.
It is in the contract. Contract
It
no
is
hai
in
na?
the contract. My lord, they are attempting to derive the source from the contract. Faithful performance clause. My lord, in 2015 guidelines, they refer to that clause. But in 2001, they don't refer to that clause. So, my lord, this is an improvisation at their end. Because when the law says, my lord, ESMA Act and 2000 orders, what is MDG? My lord, we have to go by the law of the land. We cannot go, my lord, with what the respondent professes, that it is relatable to the faithful performance contract. In 2001, they were not wise enough. When the Karnataka High Court order came, they became wiser. And then they, my lord, wrote a foreword trying to, my lord, show their magnanimity and magnitude of the application of the guidelines of the 2015. My lord, no doubt that it is intended to serve the public. But the rights of the public are to be protected not at the cost of the rights of the distributors. That is my submission.
That's all. We conclude the argument here
Yes.
and you file your notes.
Yes. Yes.
And while filing your notes, you quote the relevant clauses.
I'm sorry, ma'am?
While filing your note, you quote the relevant clauses. Right? Whatever are the clauses, you just quote it. Okay? Or you can refer it from page number of the records. That is also possible.
It is there in Tara Enterprises also. That faithful performance clause.
That
there
clause is in the every agreement.
In
But
every
that clause
again
is every
in MDG guideline. It is not required to again quote that. It has to be there in the.
My lord, I may just indicate.
Arguments concluded.
Yes, arguments concluded.
The parties may file their short synopsis of arguments on the basis of whatever has been referred to during the court proceedings and only on the judgments which has been cited by the respective parties in the court proceedings. उसके अलावा नया कहानी
नहीं कुछ नहीं. My lord, I must only indicate
See,
there is one writ
the
petition.
needful will be done by 15th of October.
My lord. But there is one writ 6496 of 2011 SK Gas Services.
Yes.
My lord, I don't have a vakalatnama. I had contacted the client. They indicated their intention not to contest.
कौन सा वाला?
That is 6496 of 2011.
Item 5.
ये लिखिए 6496 of 2011 इसका अलग से ऑर्डर ड्रॉ करेंगे. You have a वकालतनामा?
No, I don't have it.
Who has the वकालतनामा?
I'm sorry, madam.
Who has the वकालतनामा?
Mr. Abhay Kumar Tiwari.
Okay, so he is not appearing.
He is not appearing today, madam, because I was in.
Nobody appears on behalf of the petitioner in this writ petition. nor any prayer for adjournment has been made. The counsel for the Mr. Rupesh Singh submits that
I have got no instructions with respect to that.
he has no instructions in this case, and he does not hold wakalatnama for the petition. Accordingly, considering the aforesaid circumstances, this case was to be heard along with the batch matter of 4 other analogous cases and was tagged with them. In other matters, the arguments have already been concluded. Since nobody is there to pursue this case, this petition is dismissed for non-prosecution. Into order vacate.
On more judgment, my learned friend has cited that imposition of penalty is a civil obligation, and probably your lordships are aware it was passed in Guljag industry.
आप लोग साइट ही नहीं करते.
We'll put that in our notes.
Citation बताइए.
2007 volume 7 SCC page 269. 2007 volume 7 SCC 269 Guljag Industries versus Commercial Tax.
There are other judgments also arising out of contractual obligations.
That we find. And
अब नहीं अब.
अच्छा ठीक है नहीं. We
अब
can put
खोजना
it
मेरा
in
काम
note.
है. अब हम आपको
अच्छा, ठीक.
जितना साइट किए हैं उसके अलावा एक
नहीं वो नहीं
साइट
हम लोग
करेंगे.
we can put it in our notes also. अच्छा ठीक.
नोट में क्या डालना?
ठीक.
So reference के लिए डालना आप.
But I will not have an opportunity to respond.
You don't need to
You
respond.
just-
No, I
आप
don't.
मानो डालिए नहीं मानो मत डालिए. हम अपना ही रिसर्च कर लेंगे. आप लोग तो करेंगे नहीं.
We will do that.
I'll do my own homework. Don't worry about it. इसको टैग करके पूरा टैग. Yes.
Maximum 10 minutes the affidavit will be ready. There the parties are there from court. Maximum. Only 10 minutes is maximum.
I can find some.
हाँ, ये वो अभी आने वाला है.
Paso case, item 2 from the list, WPL 193 of 2015.
Where is the petitioner? The matter was passed over. आप हैं?
हाँ,
हाँ.
petition हम हैं और वर्कमैन तरफ से एसोसिएशन यूनियन है, उनका कहना था कि हो गया है उनका रिटायरमेंट, तो हम तो श्योर नहीं हैं, हमको थोड़ा पता लगाना होगा.
क्या पिछली बार भी इसीलिए एडजर्न हुआ? अब पता लगाने का स्कोप नहीं है. मेरिट में बहस करें.
अच्छा ठीक.
उनको आप पोस्ट रिटायरल बेनिफिट्स नहीं दे रहे हैं because of pendency of this case which was recorded on the last time.
रिटायरमेंट तो ट्रांसफर के अगेंस्ट में आए थे
और रिटायर कर गए, लेकिन पोस्ट रिटायरल बेनिफिट नहीं दे रहे.
नहीं उसमें
Right? यही है. ये पूछ लीजिए, लास्ट टाइम भी यही हुआ.
नहीं तो अभी
नहीं, इसमें डेट वेट का कोई
नहीं कोई बात नहीं. ठीक है.
आप लोग बहस करें.
इनफ्रक्चुअस हो गया है, रिटायर कर गए, कोई रिटायरल बेनिफिट का नहीं है इसमें.
Already, retirement benefit is not there.
नहीं नॉट क्लियर.
It has been filed in 2015, and in 2017, the respondent retired.
Infructuous, हाँ,
लिख दें Infructuous. WPL number 193 of 2015. The learned counsel for the parties are present. Counsel for the respondent submits that the present case has become infructuous as the matter arises out of an order of transfer and the award passed by the learned labour court, learned Central Government Industrial Tribunal number 2 Dhanbad. And during the pendency of this case, the respondent has already attained the age of superannuation. The learned counsel for the petitioner submits that the petitioner has got no up-to-date information regarding the retirement of the respondent. But if the respondent has already attained the age of superannuation, nothing survives in this case. Having recorded the submission of the learned counsel for the respondent, this writ petition is dismissed as infructuous.
Also, case item 30, WPC 4082 of 2020.
Lordship, pass over from one or two cases. My senior is late in September 5.
सुबह में केस था हमको बुला लिया
ये
गया
डिस्काउंटेड की तरफ से
बुला गया कि आप पूजा कर रहे हैं, हम बोलिए 2:15 बजे तक पूजा हो जाएगा तो आ जाइए।
हम उसी के चलते आ गए, इसी केस के चलते
आप ही बहस करिए सर।
इसमें तो कुछ नहीं, इसमें जो इनको नोटिस मिला था सेक्शन 4 का,
कहाँ है
नोटिस एनेक्सर 5 उसके अगेंस्ट में आ जाए, ये वहाँ अपीयर भी किए हैं, वहाँ अपीयर
के अगेंस्ट में क्यों आ गए हैं?
वहाँ अपीयर किए,
क्या स्टेटस है?
वहाँ कुछ नहीं हो रहा क्योंकि हाईकोर्ट में आ गए थे, वहाँ कुछ नहीं हो रहा है, वहाँ जाके वहाँ 3 डेट में अपीयर भी किए हैं, वहाँ जाके अपना जवाब देते हैं।
आप क्यों नहीं वहाँ जाते?
वहाँ गए भी हैं 3 डेट में, फाइल द काउंटर एफिडेविट इन व्हिच आई इंक्लोज द ऑर्डर।
कहाँ है आपके काउंसिल? नहीं,
मेरा काउंटर एफिडेविट का पेज 14
इनका सूट का क्या कहानी है?
ये सूट में इनका सूट जो था, सूट अलाउ हो गया था, अगेंस्ट दैट वी हैव प्रेफर्ड द अपील वाज इन व्हिच द लिमिटेशन वाज सर्टेन डेज, दैट लिमिटेशन वाज allowed, that against that order the petitioner preferred the CMP before this order and the CMP was allowed and my appeal was also dismissed. Against that order not I preferred the SLP.
That is pending.
That is
तो अब यहाँ पर क्या बचा है? अब तो टैक्ली इनका फेवर में ऑलरेडी।
हाँ, तो हम एक तो बोले कि यही बात जाके वहाँ सेक्शन जो 4 का नोटिस है, वहाँ यही बात जाके वहाँ दिखा दें, वहाँ तो अपीयर भी कर रहे हैं और समय ले रहे हैं।
या वहाँ जाके क्लोज करवा दें, है ना? क्लोज करवा दें।
हाँ,
ठीक है, आप हैं इसमें?
yes,
ये बोल रहे हैं कि एज ऑफ नाउ, ये बोल रहे हैं कि एज ऑफ नाउ, since you have won the title so far, you inform the authority and get the matter closed.
वहाँ जाके खाली आप
वहाँ जाके आप अपीयर हो जाइए। आप ऑलरेडी 2-3 डेट में अपीयर हो चुके हैं, टाइम ले रहे हैं।
कहाँ पे?
जो जिसके नोटिस हुआ है, दिस अथॉरिटी।
स्टेट अफसर
नहीं मतलब क्या कह रहे हैं 2017 मतलब टाइटल सूट वाज डिक्लेयर्ड इन माय फेवर।
अरे बोल तो रहे हैं टाइटल आपके फेवर में डिक्लेयर हो गया।
हाँ, उसके बाद 20 में नोटिस किए, उसके बाद ये अपील किए, अपील
अरे भाई सब चीज सही है,
हाँ।
आपकी सारी बातें लिखा दे रहे हैं। ये अभी एसएलपी में गया,
हाँ एसएलपी गया है।
एसएलपी में, ठीक है? तो व्हाट ही इज सेइंग इज दैट you intimate the authority regarding this and then the proceeding will be closed automatically.
ये तो आप खुद लाए हैं, ये भी लिखे हैं कि ये हम सुप्रीम कोर्ट गए हैं।
तो सुप्रीम कोर्ट में है तो फिर
तो अपील का टाइटल अपील का ये तो
एक टाइटल इविक्शन तो टाइटल से ही ना चालू हो रहा है।
हाँ,
नहीं,
बिल्कुल।
आपका टाइटल नहीं है तो भी इविक्शन
इविक्शन कर दिए।
इसमें
नहीं करेंगे ना?
नहीं करेंगे।
हाँ तो फिर
हाँ, तो वही तो ये विदाउट जुडिशियल कैसे कर सकते हैं 2020 में? जुडिशियल मतलब एटलीस्ट इलीगल तो है ही, बिकॉज इन 2017 मतलब suit was declared in my favor.
Will it be sufficient to observe that if you ultimately get the title, you may proceed
Then
afresh?
only, yes.
That is sufficient.
Yes.
Close कर देते हैं।
हाँ,
यही पर close कर देते
ठीक कर दो।
हैं। WPC number 4082 of 2020. The learned counsel for the
In fact, when the land was acquired in the when the NCDC was there, thereafter entire land was vested to CCA, and petitioner was unauthorized occupant, and he, although he has obtained the degree in his
ये वही
favor.
है क्या जो हम
एक
डिसाइड किए थे
एक
इसका
एक
फर्स्ट
ये थे मुस्लिम अंसारी वाला
हम तो याद
यस
ना।
मिनट्स वो वहाँ कोर्ट
वो
नंबर
चल रहा
7 में
है।
जब बैठे थे हाँ यस वैसा ही है मैटर
मैटर नहीं है।
वही है
वो
ये
चल
लोग
रहा है,
क्लियर
सुप्रीम कोर्ट
उसमें
ने
भी हाँ
decide
उसमें अभी वो भी मैटर सुप्रीम कोर्ट में है आइडेंटिकल मैटर उसमें बोलते थे कि हम
Additional
एक्वायर
evidence-
किए हैं
एडिशनल एविडेंस का
हाँ एडिशनल एविडेंस का जो पॉइंट था जिसमें आइडेंटिकल ही है एक तरह से जब ये बोल रहे हैं कि हम एक्वायर किए हैं
अब छोटा सा ऑर्डर है सुन लीजिए
यस
WPC number 4082 of 2020. The learned counsel for the parties are present. District petition has been filed for the following relief. The learned counsel for the petitioner submits that with respect to the same property, there was a title suit between the parties, and the title was declared in favor of the petitioner, and the appeal was also decided in favor of the petitioner.
No, notice appeal was barred by 1,000 to
Ultimately
50.
decided,
हाँ वही सिर्फ कॉन्डोनी हाँ
the appeal by the High Court was also decided in favor of the petitioner.
Yeah.
petition
Now the state has filed,
CCL
the respondent has filed SLP before Honorable Supreme Court. नंबर बताइए।
हाँ उसका डायरी नंबर है
डायरी नंबर पे चल रहा अभी तक।
अभी तो कल ही 28 को फाइल किए हैं डायरी नंबर 45163 of 24
4
5
1 6
3 of 24 just 3
which is diary number 45163 of 2024 filed on 28/9/2020. The learned counsel submits that as on date, the respondents do not have any locus to evict the petitioner from the same property under the provisions of the Public Premises Eviction of Unauthorized Occupants Act 1970. He submits that they may have fresh cause of action if they ultimately win before the office. The aforesaid history of litigation as narrated by the petitioner is not disputed by the learned counsel for the respondents. He submits that right may be reserved with the respondents to proceed afresh if the decision ultimately, if the case by the Honorable Supreme Court is decided in favor of the respondents. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances, and as on date, aforesaid facts and circumstances, this court is of the view that the respondents cannot proceed against the petitioner pursuant to the improved notice dated 27/10/2020, as the title with regard to the property is in favor of the petitioner so far. With this observation, this writ petition is hereby disposed of, and
notice set aside.
just a moment. Accordingly, the notice dated 27/10/2020, within bracket annexure 5, is hereby set aside. The liberty is reserved with the respondents to take fresh steps as and when subject to the final result of the case before.
Let's one small favor. They have disconnected my electricity and water
ये
pipes.
Yeah. ये चीज हम लोग
अच्छा ठीक है ये ऑब्जर्व कर दिया एटलीस्ट
CCL इनको लाइट की
हाँ दिए हैं समझे गाँव को देते हैं
इसके लिए अलग प्रोसीजर।
यस
Item 17, WPL 2077 of 2023.
Yes.
Telling the award by the level court guard without seeing the fact of the case and the order to please 50% back wages with other consequences related to the retirement of the appointed party number 2, Your Worship. So now the appointed party number 2 has attained the age of superannuation. There is no chance of appeal. And the second thing is that he has dealt with the that law that he has not pleaded about the gainfully employed, and he has awarded 50% back wages as a mechanical man, Your Worship. And the third is, Your Worship, he has granted us only 2 days for pleading our evidence and close the dates. So we have categorically stated in our petition that during that period we are changing our lawyers, so we could not follow up the matters. So we could not attain on the said dates, Your Worship.
What were the dates?
Yes, Your Worship. The dates here, I have just printed the copies of the dates here, Your Worship. 20/6/19 and the other date is 1/7/19, 1/7/19 और 18/7/19 को ये हमारा एविडेंस क्लोज कर देते हैं. Earlier this matter was sent to the mediation. I think mediation was has failed, so that's why it has come up today. Actually, what had happened?
There was a time granted by you by way of there was time granted by you on 26/2019 when the matter was again on that day you were and then it was taken up on 1/7/2019.
Yes, sir.
निश्चित रूप से 18/7 को प्रस्तुत करें, नहीं तो उचित आदेश पारित किया जाएगा.
Yes,
19/7 को ना आप अपीयर हुए ना आपका गवाह अपीयर हुए.
क्योंकि उस समय हुई क्योंकि हम लोग जो हमारे काउंसिल थे.
What is the explanation for non-appearance on 18/7/2019? Although you were aware that on 1/7/2019 a strict order was passed.
Yes,
It
that
was
is
not a usual
That is
adjournment.
on record that we have not filed any application for recalling of that order. That is on record that I have not denied, Your Worship. So, but on verbal instruction, I have just stated in my writ application, para 22 and 23 also, that during that
You
period,
see, you did not even take steps to file a petition for recall of that order.
Yes,
or to
yes.
give you an opportunity to do
yes,
so.
yes, yes, that is the.
Even that you have not taken any steps. The impugned order has been passed much later. This is, see, this has been passed on
The award was
16th of December 22.
Right.
So,
The award was passed much
Yes.
later on, Your Worship.
you have not taken any steps. Your evidence was closed. You were sleeping over it. Now he has already attained the age of superannuation.
During that period itself,
When did he attain the age of superannuation? What is your age of superannuation?
that
देखिए कुछ भी नहीं है. ये टिन प्लेट का जजमेंट बहुत क्लियर है. Even if there is no evidence, the court has got the jurisdiction to grant 50% back. यही तो है टिन प्लेट का जजमेंट.
नहीं, but what had happened? एक ऐसा रिपोर्ट आया कि फैक्ट्री में कुछ चोरी हो रहा है. Then we installed a CCTV camera. He got on the CCTV camera. Then we called him. Then he just गिड़ाने लगा कि नहीं हमको छोड़ दीजिए कर दीजिए. तो फिर just after next day he did not turn up for his work and he just went before the EPF department and form 19 he just filled up. Can you see NHS 7 at page 28? This is ये फॉर्म 19 है हुजूर, वहाँ से वो EPF का पैसा आपने उठाए हैं जिसमें ये लिखे हैं 6 में नौकरी छोड़ने का कारण रिजाइन. और just after this withdrawal of the money from the EPF, he made a complaint to the labor superintendent.
You must have filed your written statement.
Yes, Lord.
ये सब लिखे हैं उसमें.
ये सब हाँ लिखे हैं.
बताइए कहाँ लिखे.
पारा 6 में जो लिखे हैं ये पेज 22 इंटरनल पेज 22 है वैसे. पारा 6 then
इंटरनल पेज 22. वो क्या चीज़ है? इसका रेफरेंस तो कुछ नहीं दिया ना.
हाँ जी.
इसका रेफरेंस ही नहीं दिया. You are not mentioned
Plus-
about all this. जब ये सब कागज यहाँ ला रहे हैं उसके बारे में काफी बोलिए. How many witnesses were examined from the side for the plaintiff?
only sole
For the
witness.
workman?
Only sole witness he has. Although on his complaint, labor superintendent has verified our record, and we have submitted the CCTV footage also. But just before completion of 45
उनके अगेंस्ट में कोई डिसिप्लिनरी प्रोसीडिंग्स तो नहीं की?
नहीं वो नहीं किया,
कुछ भी नहीं की.
वो नहीं किया है, वो नहीं किया क्योंकि ये खुद से ये सर्विस छोड़ के चले गए और फिर वो कभी आए ही नहीं. और अचानक से फिर जाके ये नवंबर मंथ में ये लेबर सुपरिटेंडेंट बोकारो को ये कंप्लेन करते हैं.
See, when he was not there, आप चोरी का allegation था, you caught him red-handed or whatever. You did not issue any show cause to him.
तो क्योंकि वो इतना बिगड़ाने लगा कि चूंकि जस्ट ऑन मर्सी द मैनेजमेंट हैड लेफ्ट.
Your management is at
कि हाँ, ठीक,
at his mercy.
छोटा सा जो यूनिट है उसका
नहीं,
बेसिकली,
छोटा, बड़ा
लेकिन हाँ
unit का
उन
बात
लोगों को
नहीं।
करना चाहिए था लेकिन उन लोग किया नहीं.
वो चला गया लेबर को.
किया नहीं. लेबर कोर्ट तो ये गया वो, लेबर कोर्ट वर्कमैन गया
Workman.
after assigning the reason that he had resigned from the service, and this fact has also not considered by the labor court. Yes, sir.
Even finding CCTV footage was not produced, not any
And without and without waiting for the conciliation report, he approached the labor court because the matter was pending before the conciliation officer, and without
What is the date?
before the consideration.
When did he approach? Give me the date.
He Annexure 1 we see Your Lordship because
Where is the he approached under 2A.
2A right now.
The 2A proceeding.
2A because just after the
Let us see. When did he approach? He went there on.
he
When
approached
was the case filed?
in the month of because he approached the level superintendent in the month of November 30, Your Lordship.
Just a minute. He filed the case on. Give me these dates. (28) 2014. He filed the case, right? When did he last work?
He last worked on July 13th है 30 July 13 as per the Annexure 7 Your Lordship. And he approaches the level superintendent in the month of November.
He discontinued from which date?
30/7/13
Right? He approached the labor superintendent when?
in the month of November
From where you say?
13 from Annexure 1 Your Lordship.
Accept to
On his complaint made in the month of November, labor superintendent had asked us explanation. We submitted the
Where is
explanation.
his written? He approached on 23rd November 2011, 2013.
Yes.
When did 45 days expire?
तेईस 11 को जो कंसिडरेशन था तो 45 डेज हो गया 23 से 11 23 से 12
उन्होंने अपना केस फाइल किया 20/8 तो 45 डेज तो एक्सपायर हो गया 45 days expire हो गया condition
January
the
14.
provision itself says that if no reply is received within 45
No,
days
I'm not on get that. I'm just saying that when he himself said that I'm resigning from the post, and just
no,
after
where do you say this? You see,
Annexure 7 we can't be seniorship
we can't see your annexures here. You have not led any evidence.
because
We
they-
will only see the
because-
improved order and the records before us. We will not see anything.
because during that period we had I mean to say the management are changing their lawyers, so they could not attain that date. And
The award was passed in the year 2022. What were you doing since then? You were looking for an advocate. नहीं मिला आपको एक भी ढंग का.
इन लोगों ने फिर
बस ठीक है, इसमें कोई आपका कोई दम नहीं है. Unnecessarily. कब से काम कर रहे थे आप? Since when have you worked? Where you worked?
1985 से
85.
हाँ was appointed on 19/9/85.
95 लिखे होंगे. Where is saying 85? और चूंकि वहाँ मैनेजमेंट ने कोई भी लीड नहीं किया एविडेंस, तो बहुत सारा डॉक्यूमेंट्री प्रूफ भी हम लोगों ने वहाँ पे नहीं एग्जिबिट करा पाए या नहीं प्रोड्यूस कर पाए.
मैनेजमेंट कोई नॉविश नहीं है ना, इलिटरेट भी नहीं है ना. ये सब इलिटरेट लोग का आर्गुमेंट है कि हमको पता नहीं चला, हम जानते नहीं, हमको कुछ नहीं पता, मर्डर हो गया. यही है ना आर्गुमेंट. हम नहीं जानते, हमको नहीं पता, हम इलिटरेट हैं, लेकिन बाकी सब चीज़ हम
खाली मेरा ये पेड़ था कि सिर्फ हमको एविडेंस लीड करने का खाली हमको दिया जाए
नहीं.
सो दैट कि जो इम्पोर्टेंट डॉक्यूमेंट्स है वो तो कम से कम हम अपना ये प्रोड्यूस कर सकें. और ये जबकि खुद ही ये जाकर के ये सही में लिख रहे हैं, एक तरफ बोलते हैं कि यस आई हैव रिजाइन, और दूसरी तरफ ये जाकर फिर वहाँ कॉन्सिलेशन अफसर के यहाँ फिर वो केस भी फाइल करते हैं.
बिना रिजाइन लिखे जो है ना, पीएफ का पैसा हमको मिलेगा ही नहीं. आप उनका मजबूरी समझो, नहीं जाएगा, नहीं मिलेगा. ये सब कोई रीजन नहीं.
नहीं तो फिर तो ये तो फिर कॉन्ट्रडिक्टरी हो ना, फिर तो
कुछ नहीं कॉन्ट्रडिक्टरी.
तो ये
देखिए,
तो भी अच्छा दूर किया, आप चोरी करिए और फिर
शो कॉज नहीं किए,
फिर
इंक्वायरी
वहाँ-
नहीं किए,
फिर
एक
वहाँ आप
डिसिप्लिनरी
ही मैनेजर का फॉर्म ही पकड़
प्रोसीडिंग
लीजिए.
जस्ट अ
अब-
मोमेंट. शो कॉज नहीं किए, इंक्वायरी नहीं किए, राइट, कोई डिसिप्लिनरी प्रोसीडिंग इनिशिएट नहीं किए. आप उनको ओपन कोर्ट में चोर कैसे बोल सकते हैं?
क्योंकि सीसीटीवी फुटेज जो हम
सीसीटीवी
जो था वो हमने कॉन्सिलेशन अफसर को दिया, उसको वो पूरा हमारे यहाँ से वो लेके गए.
It was not produced.
is the conciliation
और उसके
officer
बाद भी
is the conciliation officer a substitute to disciplinary proceedings?
ये तो आई एम जस्ट पुटिंग अ क्वेश्चन टू माय
But
सेल्फ
you
हियर आल्सो.
you put question to
So,
yourself, but
अगर
there is no merit in this case. WPL number 2077 of 2023. Heard the learned counsel for the parties. This petition has been filed for quashing the award dated 16/12/2022. Passed in ID case number 1 of 2024 by the learned presiding officer Labour Court Paro, by which the award has been passed in favor of the workman, and the petitioner management has been directed to pay 50% back wages along with other consequential benefits from 26/6/2013 till the date of superannuation of the petitioner. You have attained the age of superannuation. During the pendency only he attained the age of superannuation.
the pendency of the
When? को date
reference.
बताइए.
that is not from
The learned counsel for the petitioner has
that he
submitted
has to
that
say,
the respondent has attained the age of superannuation
and he has not pleaded about
during the pendency of the case before learned Labour Court. The learned counsel submits that the grant of 50% back wages is perverse in as much as the workman did not plead and prove that he was not gainfully employed after he discontinued to work. The learned counsel has also referred to Annexure 7 to the writ petition to submit that
line 3 judgment scholarship on the back pages of the Honorable Supreme Court.
did it.
And I forward.
The learned counsel has also referred to Annexure 7 to submit that the workman had gone to the office of the Employees Provident Fund man had filled up the form to take the terminal dues by stating that he had resigned.
But actually, in view of Annexure 6,
The
date of birth is
कब फाइल की थी? What is the date of filing of Annexure 7?
Annexure 7
What is the date?
Annexure 6 में 6/11/1967 डेट ऑफ बर्थ लिखा हुआ है। टर्मिनेशन 2027
इसका
में
ESI में
आप
दूसरा-
बताइए ना इसमें डेट कब गए थे? ये
ये-
कब गए हैं?
ये
Annexure
साइड
7
में-
का डेट कब है?
ESI में हुजूर ये
25/5/13 लिखा हुआ है Annexure 6 में
डेट बताइए।
25/5/13
8 7 नहीं ये तो
ना ना
8 7 14 का
पेज 27 में 25/5/13
अरे वो नहीं पूछ रही है ना वो
However, during the course of argument, the learned counsel for the petitioner,
जुलाई में
देखो 14 में 8/7/14
नहीं वो तो जो वो कोर्ट का वो है
नहीं नेक्स्ट पेज में पेज
हाँ वही नेक्स्ट पेज
29
में हुजूर हाँ वो कोर्ट का वो
कब गया है? इसका तो कुछ पता नहीं चल रहा।
जुलाई में है जुलाई
कहाँ
13
कहाँ से?
क्योंकि ये लिखते भी नौ
30 साल तो छोड़ने की तिथि है।
हाँ
अप्लाई कब किए थे? However, during the course of argument, the learned counsel for the petitioner is not in a position to give the date of filing of Annexure 7 by the responding workman before the authority under employees provident consent. The learned counsel has further submitted that only 2 dates were granted to the management to lead evidence, and thereafter the evidence was closed as back as on 18/7/2019, and therefore sufficient opportunity was not granted to the petitioner management to lead evidence. He has further submitted, on the merits of the case, the counsel has further submitted that the respondent workman was caught being engaged in theft in CCTV, but during the course of argument, he does not dispute that no disciplinary proceeding as such was initiated against the workman, and the workman had approached the London Labour Code under Section 2(a) of the Industrial Disputes Act as he claimed to have been discontinued from service from 26/6/20. With respect to the back pages, the learned counsel has relied upon judgment passed. कौन सा judgment?
तीनों है हुजूर उसमें फर्स्ट है ये 2005 1 SCC 363
The judgment passed by
पारा 16 है उसका फिर
the judgment reported in bracket 2005 bracket close 1 SCC 363 para 15.
and second one
And judgment reported in bracket 2006 bracket close 1 SCC 479 para 52, 53, 56, 61 and 62, and also para judgment reported in bracket 2018 bracket close 18 SCC 299 para 11, 12 and 17. The learned counsel submits that the onus is upon the workman to plead that he was not gainfully employed. Plead and prove. And only under such circumstances, the workman can be entitled for back wages. The learned counsel appearing on behalf of the responding workman by opposing the pair has submitted that the learned labour court has passed well-reasoned order which does not call for any interference. He has submitted that that sufficient opportunity was granted to the petitioner to lead evidence, which they did not choose, and the evidence was closed way back as on 18/7/2019. And the award was passed only in the year 2022. The learned counsel submits that the case be decided on the basis of the materials which were placed before the learned labour court, and no fresh material can be taken into consideration once the management did not need any evidence. He submits that no interference is called for. With respect to the back wages also. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, and as per the records of this case, the workman had worked with the management till 26/6/2013. And thereafter, the workman claimed to have been discontinued. The records reveal that the workman had approached the concerned authority for conciliation on 23/11/2013, and ultimately, when no result came up, the workman had approached the learned labour court by filing petition under section 2(a) of Industrial Disputes Act on 28/2013. Before the learned labour court, the workmen as well as the management, they filed their written statement, and the evidence of the workman was closed on
30th of May,
35/2019. 2019. Yes. The records of the case reveal that on 26/2017, the management was directed to produce certain documents, but the order dated that the management had only filed attendance to the advocate, but neither the advocate was appearing on that day, nor the order dated 26/2017 was complied. And on 30/5/2019 itself, it was observed that adverse inference will be drawn against the management on account of non-compliance of order dated 26/2017. And thereafter, on the same day, the evidence of the workman was closed, and the next date was fixed for the evidence of the management on 26/2019. On 26/2019, the attendance of through the advocate was filed, but when the case called out, neither the counsel appeared nor any evidence was produced. The next date in the matter was 1/7/2019. On 1/7/2019, attendance was filed on behalf of the parties, but when the case was called out, the advocate did not appear, nor any time petition was filed. And by way of last indulgence, the matter was directed to be posted on 18/7/2019 for production of evidence by the management. On 18/7/2019, the attendance was filed, but when the case was called out, neither any witness was produced, nor the management appeared, nor any time petition was filed before the court. The court, by a recent order dated 18/7/2019, closed the evidence of the management. The matter was ultimately decided. matter was ultimately decided against the management by the improved order. During the course of hearing, it is not in dispute that although an allegation of theft was sought to be leveled against the workman, but admittedly no disciplinary proceedings was initiated by the management against the workman. The learned court considered the materials on record and ultimately held that the workman was not allowed to work in the factory of the management from 26/6/2013, and the oral termination of the workman from employment was found to be in violation of principles of natural justice. The learned court has recorded that there was no question of any reinstatement as the workman had already crossed the age of superannuation. The report also recorded that the workman has been victimized by the management and the termination of the workman was not justified, and ultimately awarded 50% back wages with other consequential benefits from 26/6/2013 till the age of his superannuation, by referring to the judgment passed by this court in Tinplate Company of India Limited versus TBR Raju, reported in 2021 within bracket 1 bracket close GLTR 176. And wherein it has been held that the quantum of the entitlement of back wages would depend upon the judicial discussion, taking into consideration the nature and the charges against the employee and the pleadings based with evidence regarding gainful employment. This court is of the considered view that a finding of victimization has been recorded by the learned court, and the learned court has recorded that the workman was orally terminated without following the principles of natural justice. It has come on record that it was also the case of the workman that the workman has been working since 1998. This court finds that the learned court has passed a well-reasoned order by giving 50% back wages from 26/6/2013 till the date of the superannuation, particularly in light of the fact that there is a finding of victimization of the workman. So far as the argument of the petitioner by referring to Annexure 7 is concerned, on the perusal of the same, the same cannot be taken into consideration on account of two reasons. Firstly, the same did not form a part of the record of the learned court. Secondly, on perusal of the said document, it is not clear as to the date on which the workman
exhibit before the level court.
was exhibited.
Yes, yes.
Exhibit number.
Exhibit number 4. And you see page 35, Your Lordship.
What is the date of filing of this document?
That is not there in his
It is not
application.
It is not there.
Yes.
From the
वो लिख रहे हैं कि 30/7 को छोड़ चुके हैं, मतलब कि वो 30/7 के पहले ही वो गया होंगे, ठीक आफ्टर कंप्लीशन ऑफ द 30/7 के बाद वो गया होंगे.
from the pedestal of the document as contained in Annex 7, which has also been found in the records of the learned court. Exhibit तो इसमें mark नहीं है.
4 है. Exhibit A4, photocopy of EPF statement, which we have put on.
This is not EPF statement.
हाँ. EPF
EPF statement अलग है. Anyways, it is not clear as to when the workman had approached the Employees Provident Fund Authority for taking his terminal dues. Although he had mentioned that he had resigned on 27/2015, this court is also considering that the said document does not have any bearing in the matter. ये तो नेक्स्ट डेट में 8/7/14 तो लिखा ही हुआ
वो जब ये सर्टिफाइड कॉपी निकाले हैं
है. ये लास्ट में
हमारा
लेबर कोड का नहीं.
लेकिन ऊपर जो देखिएगा राइट
बैक साइड में जो ये रखा हुआ है प्राधिकृत अधिकारी का हस्ताक्षर.
हाँ. उसमें वो देखिएगा वो उसमें
8/7/14
सील भी है.
8/7/14
सील भी है.
हाँ.
और उसमें डेट भी मेंशन किया हुआ है. वो लेबर कोड का सील है.
लेबर कोड का सील कैसे है?
क्योंकि वहाँ से ये सर्टिफाइड कॉपी निकाला गया था तो उसी का सील है.
सर्टिफाइड कॉपी निकालने का सील नहीं है.
हाँ उसी का, क्योंकि उसको
ये सर्टिफाइड कॉपी निकालने का सील ही नहीं है.
कुछ
बैंक लिखा हुआ है.
हाँ, कुछ बैंक का
तो लेबर कोड बैंक है क्या?
नहीं. So it is not clear.
नहीं it is
It is not clear.
बैंक से जाके सर्टिफाई कराया होगा कि पैसा जमा है.
हो सकता है. क्योंकि यहाँ ये दिख रहा है कि 30/7 को, तब ये 8 साल, अच्छा हाँ 1 साल के बाद ये बेसिकली ये वेरीफाइड हुआ है कि पेमेंट आया है. जो भी मतलब व्हाटएवर लॉस है.
However, at the back of the state document, it may not be even there. Considering the totality of facts and circumstances, this court finds no reason to interfere with the reasonable order and Article 226 award and Article 226 of the Constitution of India. Accordingly, this petition is dismissed. ये जो judgments हैं हम आपको deal करेंगे. 3 judgment आप दिए हैं ना? You find it in the order. Victimization के finding के बाद back wages तो मिलना ही है.
क्योंकि जो अभी ऑर्डर पास कर दिया आई कांट से क्योंकि सुप्रीम कोर्ट क्लियर बोलता है कि यू हैव टू स्टे एंड प्रूफ दैट यू आर नॉट बीन फुली इम्प्लॉयड इन एनी मैनर.
You will find it. हम वो एक पे किए हैं सारा ये सब जजमेंट डिस्टिंग्विश किए हैं हम ऑलरेडी, इसलिए हम अभी कुछ नहीं बोलेंगे.
सो दैट इज द सुप्रीम कोर्ट बेसिकली.
Also, case item 5 from supplementary legislative PC 2623 of 2021.
Will not permit this supplementary affidavit has been signed. That's not upon the other side also.
You have got it? What is it?
Well, the para 2, I have indicated the exact lot number over which the Dharam Kata and the house is constructed. I have also annexed the meteorological department issued my license to run that Dharam Kata. I have also annexed the Nagar Nigam Panchayat is given
This
the
is
holding tax.
this is situated on plot number 5171, part 5173 and 517.
Yes. And a photograph also annexed, page 617 and 18. And this is how it is placed, because the road has already been constructed by the NHI. It is just the size, the service lane is concerned.
The learned counsel for the parties are present. The learned counsel for the petitioner has filed a supplementary affidavit today. It is taken on record, copy of which has been served upon the learned counsel for the state. The learned counsel for the petitioner submits that the respondents have issued notice to demolish the existing structure over the property, which is on plot number 5171 partial, bracket close, 5173 and 5174, which comprises of the house, shop and dharam kata. The learned counsel has also submitted that the highway has already been constructed.
Your Lordship, the service lane and the drainage is building, Your Lordship, and due to hindrance of the petitioner.
Just a moment. Yes, filed it. Now we will decide it.
Yes.
Okay, next date we will decide it. छुट्टी के टाइम में थोड़ा सा दुर्गा पूजा में डिस्टर्ब.
इनको disturb नहीं करें, Your Lordship.
Out of these
The
three
land
plots,
has already
already been
in the
acquired. We have
This has also been acquired.
Yes,
according
yes,
Yes,
to-
Your Lordship.
Page
And can you
20.
see my annexure A, Your Lordship, and annexure B, Your Lordship. The estate has
We will decide it. There are so many orders passed. You just stay your hands only till 14th. Right? The learned counsel submits that in view of the notice issued by the respondents during the pendency of this case, the appropriate interim order be passed. He has submitted that he shall not seek any adjournment on the next date of hearing. बाकी तो आप तो टाइम नहीं मांगेंगे ना कोई चीज का करने
We have filed our-
अगर आपको कोई मेजरमेंट करना है कुछ
measurement
करना है,
सब हुआ है.
सब हो चुका. The learned counsel appearing on behalf of the respondents have submitted that the property which has been mentioned by the petitioner in the supplementary affidavit has already been acquired. Compensation has also been paid, and the petitioner is a trespasser.
Yes.
They have also submitted that merely because rent receipt has been issued in favor of the petitioner, the same does not confer any title upon the petitioner. The title holder of the property has been given the compensation. They have also submitted that the petitioner ought to have raised the dispute before the concerned authority, and so that the matter could have been referred for the purposes of adjudication by the arbitrator,
No,
by the court,
by
by the court. The learned counsel submits that merely because the learned counsel submits that on the next date of hearing, they will also not seek any adjournment.
in the meantime, I will file any affidavit required.
Yes, they will also not seek any adjournment, and in the meantime, if any affidavit is required, the same will be filed by 14th, 15th.
Yeah, 15th.
Are you sure?
Yes, Your Lordship.
Is that okay?
Yes.
By 15th of October. Considering the fact that the matter is pending before this court, the respondents are directed to maintain status quo as on date till 15th of October 2020, till the next date of hearing. post on 16th of October 2024 under the heading of final disposal. Affidavit, if any, be filed by 16 तारीख को. ठीक है?
So there is some order to conduct an inquiry by the secretary on 9th of September. That order was there.
What
And
what
6 weeks
inquiry?
time was granted to the state. To
आप
make
लोग
an
करते रहिए, आप लोग अपना इंक्वायरी करते रहिए. एक्वायर हो गया है तो क्या ही करना है, क्या चीज़ का इंक्वायरी?
So the court's order was there to inquire about the remaining lands which were not acquired as per them. They had submitted that these lands are not acquired, but we have given the entire details. In the
सारा डिटेल दिया है?
yes, yes, yes.
So only humble indication in this. Despite the fact the counter affidavit is being filed, honorable predecessor court has looked into the matter detailed way, and there is a ambiguity is there. So therefore the direction was passed.
What is your title deed? Where is your title deed?
Nothing is wrong.
Where is your title deed?
It's a Khatyani.
Your name is there in the
It is there.
Khatiyar?
They have given the.
No, where is your Khatiyar?
I have given it's an ancestral property.
Where is your Khatiyar? Certified copy of Khatiyar have you filed?
But these persons are not tribal people. My indication is only this for the affidavit which I have given today. The land receipts are coming since ages and most.
It doesn't make any difference.
I'll just indicate in the next date of hearing.
If your land receipts are coming since ages, somebody must be there on the record.
So I'll just indicate since they have come up immediately from Kodarma, they have filed this affidavit. Deep.
आपके land receipt के basis पे हम आपका कोई
No, will not
title
claim
यहाँ
for
decide नहीं
that. Will
करेंगे.
not claim for that. If they
And
land-
ultimately, if there is a dispute with regard to your title and the person who has been paid compensation,
It's a
you have a remedy under
Yes, yes.
law.
I'm not on that.
Then
The only issue is they are not showing any document which goes to show that there is a land acquired of these areas. The only difficulty, there are two more writ petitions pending before this court.
just a moment. You have not filed any.
So that is the difficulty in this.
Supplementary counter may finally be
There is
आपने
no
देखा है
document.
सब?
Yes, yes, I have gone through every document. They are not producing the LA case number 1971. This another matter from the
LA
same.
case number means the award must have been
So
prepared.
they have said that they are saying in the affidavit that LA case number do not mention my land details into that. That is the difficulty.
only certain portions of the land, the details are not there. And so far as the supplementary affidavit is concerned, 3 plots are there. Out of 2 are totally acquired, and the amount of
आप बस वो पता कर लेंगे किस प्लॉट का नंबर आपके उसमें नहीं है.
that is there on record here.
The whole basis of filing this writ petition is there only.
We'll hear it. We'll go through the records carefully,
Deeply obliged.
right?
Deeply
And
obliged
then
for the
ऐसे haste में नहीं decide कर
Yes.
सकते. ठीक है? उतना अच्छे से ये फाइल पढ़ा हुआ नहीं है.
Sir.
Judge is seeking a judgment. Okay? I will not decide a case without reading it.
Deeply obliged for the opposition.
Item 18 from daily list WPL 2338 of 2023.
Yes, petitioner.
May I please? Your Lordship, the counter affidavit has been served on 1/10/2024. I am paying time for filing these matters.
What is a counter affidavit?
Respondent number 2 and 3 is filed. White order.
Saying what? Yes.
Will reply by filing the petition.
Lordship, we have objected on the ground that they did not have a comprehensive list of workmen to whom they are representing it.
Your Lordship, White order dated 10/9/24, we were allowed to file comprehensive list of workmen.
You have
To
filed
whom
it?
we have not filed, as the petitioner is an old citizen. We have not get the
Old
proper
citizen.
instructions from him.
Do you understand the implication of this?
I'll file the
Do you
comprehensive list on
understand
the
the
next day.
implication of this?
We have contacted with him, but we have not got the proper
So it
instructions.
must be a defective petition.
Yes.
It's not defective, it's by order dated, Your Lordship. It's a judicial order.
Because we have passed a judicial order that any person who is any writ petition which is filed by a union, they have to disclose as to who are the persons who are going to be bound by that judgment.
As Your Lordship, this petitioner is getting diagnosed with he's a cancer patient. That's why we have not got any
So there
instructions.
must be some other person representing the union.
There are 2 persons, Your Lordship.
There must be office bearers, a person who is not
I'll
keeping
get the
well.
instructions by the next date. It may be kept after.
There is another difficulty in this petition. If my lord sees the array of parties, I am appearing for the respondent number 1. If my lord sees the array of parties, Because his statement is Jharkhand Ispat Mazdoor Union through its General Secretary Sridhar Pandey. And then petitioner number 2 is Harendra Singh. If now my lord sees paragraph number 3 of the writ petition at page 5. The petitioner number 1 is a registered labour union. The petitioner number 2 is the General Secretary. In the array of parties, he is saying General Secretary Sridhar Pandey.
Award challenge किया है.
Aborting एक order है
order dated 69
issued by the Ministry of Labour refusing to abolish contract labour.
And also for the
regularization of the service of contract labor who are engaged by the contractor at the sales stockyard from time to time.
I have prepared a short list of dates for my lord's convenience. I have summarized all the pleadings and my submissions.
Which is that order which they are not compliant?
Section 5, my lords.
No, which is that order?
The last order by which we were ordered, my lord, it is order number. It is order number 10, my lords, 10/9/2024.
10/9/20. देखिए WPL number 2338 of 2023. In spite of order dated 10/9/2024, the petitioner union has not filed a comprehensive list of workmen who the petitioner is representing. How much time do you need to comply this order?
4 weeks notice. As is in hospital, we have not got any instructions from. After puja, we will comply the order.
The learned counsel for the petitioner prays for and is granted time till (29th of October) to file appropriate affidavit in terms of order dated 10/9, 11th of November. Appropriate affidavit in terms of order dated 10/9/2024, failing which this writ petition shall stand dismissed without further reference to bench.
And for rejoinder also. We'll file
पहले
the
तो आप
rejoinder
नहीं फाइल करेंगे तो आपका ऐसे ही डिसमिस
also. We will file both of them.
अब बाकी अगर आप वो फाइल करें तो रिजॉइंडर में फाइल करेंगे.
Next.
Preemptory order.
Item 19, the PL 3951 of 2023, along with item 20.
Petitioner.
Before I start my lords had a few months back when my lords were having this roster, my lords had passed an order. This is in relation to appointment of presiding officer in CGIT 1 and CGIT 2. Central
It has not been complied.
No, my lady, it has not been complied. This is another round of litigation for another person, my lady. And my lady will kindly have this order, which my lady had passed in the month of June 2024. Paragraph 3 onwards, my lady.
Yes, I have read it. I know this order. What
Yes.
happened?
Now, my lady, they say that this person who was to be appointed, he has refused to join, and therefore they have reinitiated the selection process, and they will now take 6 more months, my lady, for a proper person to be appointed to take over as presiding officer. Till then, and posts are vacant since October 2022 and October 2023. Since 2 last years, my lady, no one is working, and now 6 months again they are seeking.
A person can certainly refuse to join. So
Yes.
what आम बात नहीं
हाँ, he can.
हो जाने के बाद रिफ्यूज कर
Yes, he can refuse to
होने
join.
के पहले नहीं
But
रिफ्यूज
my-
कर
yes.
एप्लीकेशन देते हैं सब कुछ करते हैं
My request is only, my lord, till that time some alternate arrangement or
what arrangement can we make
My lord, that has been made, my lord, the paragraph, page 4 of my counter.
otherwise we will become remediless, or that cases pertaining to CGIT 1 or CGIT 2 may be transferred to some other CGIT like Ranchi, Jamshedpur, Bokaro. For 6 months, if no adjudication at all, my lady, straightforward they say that you will remain
yes
remediless.
who is there it's a matter of termination
It's matter of termination. Second one is of termination. He was dismissed with year 1998. Reference is of 1999.
what is the alternative arrangement
My lord, the remedy is, my lord, I have mentioned, my lord, in my counter, my lord, that the CGIT Asansol, my lord, we are given a trusted charge, my lord, with respect to this, till 3/10/2024, and further, my lord, proposal for extension has also been sent.
This is for CGIT 1,
In
not for CGIT.
you are concerned with CGIT 1 or 2
First one is CGIT 1, second case is CGIT 2.
And now, my lord, the same thing is, my lord, with respect to CGIT 2.
Now, one thing, my lady, what they are proposing, last order that my lady had passed in WPA number 5592/2023. This person, Mr. Dinesh Kumar Singh, was already there and he refused to entertain the case. He says that I am only alternate arrangement, and till the time regular appointment is not made, I am not obliged to see the cases. So, my lady, if my lady wants me to file an affidavit to that extent, I can file.
we will observe it that no court can say this
Yes, ma'am.
court cannot say that I am an alternative arrangement and I will not do the
Yes, yes, my lord.
लेकिन आप extension दिए नहीं।
एक्सटेंशन के लिए किया है। एक केस में वो जो 1/10/2024 तक का उनको इंटरेस्ट हुआ था चार्ज, एंड सेकेंड केस में मतलब टिल टुडे, और 3/10 और देयर आफ्टर मतलब
It has to be extended.
एक्सटेंशन में प्रपोजल वर सेंड मच अर्लियर 12/8/2024।
As of now, the alternative arrangement has also.
further extension के लिए 12/24 को भेजा गया
भेजा
जी।
extension is also under cloud
Yes, yes, yes.
अभी extension भी नहीं
हाँ, extension भी नहीं।
इतना स्लो मोशन में काम करता है जीएसटी का रिकवरी तो इतना स्लो मोशन में नहीं करता
अर्लियर मतलब द अपॉइंटमेंट वर मेड, बट द फैक्ट इज मतलब आफ्टर मतलब द एंटायर प्रोसेस
इस तरह से करके ना आप वर्कमैन को क्रश कर है ना you kill them completely उसके बाद लीगल हेयर्स को चाहिए बेनिफिट्स नौकरी से बाहर है उनको आप रेमेडी नहीं करोगे it is violative of Article 21 it is so serious the suffering continues because of your inaction.
Action has been taken already.
Action क्या
Persons who were appointed, my lord, subsequently they refused. Madam, my lord, this process again, my lord, starts.
आपको अपॉइंटमेंट का कुछ पुख्ता तरीका बनाना चाहिए ना ये कि बाद में नहीं बॉन्ड लीजिए कुछ करिए अपॉइंटमेंट इटसेल्फ इज अ प्रोसेस isn't it? होने के बाद ना बोलने का क्या स्कोप होने के पहले कंसेंट
Consent के बाद
होने के बाद रिजाइन कर देना होने के बाद ना बोल देना इट स्पीक्स वॉल्यूम्स दैट यू आर सो इंडिसाइसिव करना भी है कि नहीं करना
ultimately सारा प्रोसेस चला जाता है।
आपका मैटर कहाँ पेंडिंग
First one is in CGIT 1, and second matter that is tagged with first matter 19 and 20 is CGIT 2. Dhanbad.
आपका केस कब से पेंडिंग What is the reference number? 5 of 22. 5 of 20.
In the last order, my lady, you kindly have, my lady has In this case, last order, my lady has passed a detailed order.
Okay, WPL number 3951 of 2023 with WPL number 2016 of 2023. These writ petitions have been filed for the following relief. The grievance of the petitioner in WPL number 3951 of 2023 revealed that the reference was made to the learned Central Government Industry Tribunal come Labour Court number 1 Dhanbad as back as on 3/1/2020. But the court is vacant. Counter affidavit has been filed by the respondent number 1 revealing that the process for filling up the post is in progress. And one Dinesh Kumar Singh, who was the presiding officer CTIT cum Labour Court Dhanbad 1, completed his tenure on 15/12/2022 and by order dated 6/9/2023 he was again selected and an appointment letter was issued to him on 11/9/2023. However, he refused to join the post on 16/10/2023. And thereafter, a fresh process has begun. The matter was fixed for personal interaction of the shortlisted candidate on 27/4/2024, but the concerned agency did not recommend any candidate for the post and directed the ministry to recirculate the vacancy. The vacancy has been recirculated on 16/5/2024. And the meeting with the candidates, with the applicants has been done on 4/9/2024. Candidates have been shortlisted, but the process is not yet complete. It has been stated that the whole process may take minimum of 5 to 6 months, and in the meantime, additional charge to the post of presiding officer CTIT cum Labour Court Dhanbad 1 has been entrusted to presiding officer CTIT cum Labour Court Asansol till 1/10/2024, and a proposal for further extension of the additional charge has been sent for approval of Assistant ACC क्या हो?
ACC
For approval on 12/8/2024, which is awaited. Which is awaited?
yes,
The counter affidavit revealed that as on date, the alternative arrangement made at Asansol till 1/10/2024 has already expired, and the approval for further extension is awaited.
but now it has been obtained because counter was filed on 27/9.
The learned counsel for the respondent has stated that the counter was filed on 27th of September 24, and he is not aware about the present status, as after the filing of the counter affidavit, the additional charge of the authority has at Asansol has expired on 1/10/2024. Considering the totality of facts and circumstances, this court is of the considered view that no useful purpose will be served by keeping the petition pending, as ultimately the case has to be decided by the appropriate tribunal or level, who is entrusted with the disposal of the matter. At this, it has been submitted by the counsel for the petitioner that the in charge presiding officer are reluctant in taking up the matters, and thus additional charge remains a formality, and the litigants continues. It is sufficient to observe that in the aforesaid backdrop, as submitted by the learned counsel for the petitioner, it is sufficient to observe that the in charge court is also required to take up the matter on regular basis, and merely because the court has been given additional charge, the same is not merely for giving dates. In appropriate cases, proper adjudication is to be made. The litigants cannot be made to suffer for an indefinite period of time, awaiting filling up of regular filling up of regular vacancy.
If some judgments my lady knows on the point of that a person cannot be rendered remediless.
Yes, there is no doubt on that. I have already said that in charge court has to.
This judgment my lady has cited by the sitting litigation bench. This is constitutional bench judgment, para 15 and para 29 my lady.
In the judgment passed by the Honorable Supreme Court, reported in bracket 2016, bracket notes 8 SCC 509, Anita Kushwaha versus Pushap Sudan, para
15 and para 29.
It has been held in paragraph number 15 and 29 that by citing the principle of UP just union, that it is the state's obligation to make available to all its citizens the means for a just and peaceful settlement of dispute between them as to their respective legal rights.
One more judgment on speedy remedy. Para 23, I underlined it.
In the judgment passed by Honorable Supreme Court, reported in bracket 2013, file SCC 220, Muhammad versus Jharkhand and Aligarh, in paragraph 23, it has been held that speedy and appropriate delineation is fundamental to judicial duty. It is switchboard. Criminal jurisprudence.
28.
This court is also conscious of the fact that the matter relates to rights of labor and has serious bearing on the life and liberty of the labor and his family members. Life and livelihood of the has a serious bearing on life and livelihood of the labor and his family members. In such circumstances, it is expected that whosoever be the in charge court will take appropriate steps in connection with dealing with the matters for which the court has been made in charge, so that the disputes are taken to logical end in accordance. With these observations, this petition is dismissed. Same is the counter-appellate matter. उसमें तो CGIT 2 है ना?
Second वाले में CGIT 2.
उसमें कौन था? इसमें दिनेश कुमार सिंह
उसमें they have not disclosed anyone.
But he also refused. Refusal का क्या कहा? They apply, no, and then they refuse.
They have after appointment.
My lady, they have not even disclosed who is to come in charge basis in CGIT 2. And when, what is the penalty?
Yes, in the last paragraph, I have mentioned. In the meanwhile, additional charge of the post of the PO CGIT LC Dhanbad second had been entrusted.
उनको भी आसनसोल भेज दिया.
आसनसोल से आते हैं, like
अच्छा आते हैं.
Like in CAT, Central Administrative Tribunal, Ranchi Circuit.
Only may not some dates are different. Here may not
ठीक है
be
नाम दे दिया है ना. इसका बैकग्राउंड ना पैरा 6 से ले.
My only request is, my lady, that they may take up the charge and undertake their business, my lady, the presiding officer, because they may already shirk the responsibility.
That I have observed.
That is the only concern, my lady, because in the first order that my lady had passed, they are not willing to comply. This Dinesh Singh was then, my lady, working there as additional post, but then he denied.
They come from Asansol.
Asansol, yes.
That should be sufficient. Kafi.
Because, my lady, they want to know from the litigant where is the line where it is having stated that we are obliged to function. This is the tone of their, my lady, how they argue with the client, the litigant, the presiding officers. Therefore, my lady, 2 lines will suffice.
The in-charge court is also expected to give equal weightage with respect to take up the matters which are on his board in the capacity of in-charge court. And for that, appropriate arrangements is required to be made. The visit होगा ना उनका. For visit to the in-charge court.
Because they come, after coming they did.
ये वाला भी order लिख दें.
वो speedy just paragraph 28 is relevant.
Forgetting item 21, WPL 427 of 2009.
Lordship, I am ready in this matter, but my only
This
number
I will not hear. This one will object to?
Lordship.
Not या फिर क्लाइंट ने आपको नहीं बताया मैंने सुनी
Because this case was being listed before court number 19. Therefore, he does not know. He does not know about this listing. And matter was heard by just court number 19.
Client might not be knowing कि this case में bench है.
Item 22, WPL 1716 of 2009. Closing item 23.
The judgment passed by the labor tribunal is under challenge before the litigation. But there are two matters. The first matter, my lord, State Authority of India is the petition.
Award कब था?
The award is dated 25th August 2008.
What is the point?
Apart from other grounds, one have three primary points which is being submitted for kind consideration or objections. The first point is that there was no conciliation proceeding in which notice was issued to say it was never a party to the conciliation proceeding.
No
And
conciliation proceeding was ever undertaken.
it was never undertaken with
It is a case of termination.
The dispute is primarily between the workmen of the contractor and the contractors. What the labor tribunal did is, my lord, it said that once the proceeding started, my lord, SAIL was not even a party to the proceeding. After lapse and delay of 18 years, my lord, SAIL was issued. Once the initial reference was made, the reference was not with respect to SAIL. The initial reference, your lordship, was the reference in which it was the SAIL was there, that is 15th February 1919, your lordship. And later on, SAIL termed as the SAIL as the principal employer, and subsequently
You were made party later on.
in subsequent proceeding, your lordship.
So there are two proceedings.
Actually, why not one
I'm still not
proceeding?
able to get it. You see, this person, the contractors, he gave me do it, right? And their workmen. The difference was between them.
Roger.
Then what happened? How did sale come into picture?
They have filed their money initially, rather it is on record, your lordship, that there were two written submissions filed by the parties. In the first written submission, nothing was said against the SAIL, the concerned party. But during the course of the procedure, it came in the proceeding that eventually, invoking the provisions and in the light of the Factories Act, it was said that SAIL is the ultimate and eventual principal employer. So once the canteen which are in operation are within the present and premises of SAIL, BSL rather, to be precise, Bokaro Steel Plant. So henceforth the responsibility is being shifted upon SAIL. Whereas, my lord, no decision, no appointment, no retrenchment has been done on behalf of SAIL. If your lordship may permit, my lord, because I have prepared, but I have not prepared, my lord, the list of dates just to combine the things, your lordship, with the relevant judgment. But even if the things have been taken to be
Who had issued the order of termination?
but the termination order has been issued by the contractor, my lord. Rather, there was no grievance raised against SAIL, my lord. They have never
What
even
kind of
written
proceeding
to us.
it is, Mr. Miller?
My lord, can you
You just
let
tell
him
us.
conclude, ma'am. Let him.
No, he is not. He has not yet started.
My
And
lord, the matter
it is
has reached
already
its finality.
4:30.
My lord, the
Let
matter
me
has-
just understand what is the matter
Yes.
and what is the contours of the
Yes,
litigation.
if your lordship, my lord, kindly have a look to, for a moment, page 133.
1:30.
133, running page.
I just want to.
Yes. My lord,
Yes,
this
1:30.
point has been answered.
That's right.
This issue has been answered. 133, towards the bottom, paragraph 50. May I read it, ma'am?
Yes.
In view of the terms of reference and pleadings of the parties, the following issues are to be decided. Whether the reference is legal and maintainable, whether there is relationship of employer-employee between the worker and the management of Bokaro Steel Plant, and number 3, whether the termination of service of workmen is proper and justified. If not, what relief they are entitled to. Thereafter, my lord, finding issue number 1, paragraph 51. According to the management, this reference is bad and not maintainable because the scope of reference has been enlarged by including Bokaro Steel Plant Limited also as a party. Initially, the case was referred to the Labour Court, Bokaro, where it was registered as reference case number 4 of 1990. The workmen filed an application before the Labour Court, Bokaro, to implead Bokaro Steel Limited as a necessary party to the reference for proper and effective adjudication of the case. The Labour Court, Bokaro, allowed the petition of the workmen and impleaded the management of Bokaro Steel Plant as a party. The management objected to. Then, after hearing all the parties, the Labour Court, Bokaro, held that the Bokaro Steel Limited was necessary party. This is relevant part. Then Bokaro Steel Limited filed CWJC 1004 of 94 before Honorable Patna High Court Ranchi Bench, which was decided by Honorable Ranchi Bench. The Honorable Court confirmed the order of the Labour Court, Bokaro. However, since there were more than 100 workers involved in the reference case, the Labour Court, Bokaro, held that the same has got no jurisdiction. Thereafter, the appropriate document made fresh reference to this tribunal, and the reference is registered as reference case number 5 of 1997. This is the present reference. Again, the workmen made same prayer before this tribunal for impleading Bokaro Steel Plant as a necessary party, and the management took the same plea. Besides, no notice of demand was served by the management. This tribunal, by order sheet dated 15th of February 2000, held that Bokaro Steel Plant Limited is necessary party, and for the ends of justice, Bokaro Steel Limited should be impleaded as necessary party to this tribunal. This is also relevant. The management challenged the said order before Honorable High Court, filing CWC 1296 of 2000R. And the High Court confirmed the order of this tribunal by the order dated 2nd of January 2001. The management of Bokaro Steel Plant preferred LPA 81 of 2002. Again, the Honorable Division Bench held by the order dated 15th of December 2003 that the order passed by the tribunal was legal and justified, and the Bokaro Steel Limited is necessary party, and further held that by impleading Bokaro Steel Limited as a party, the scope of reference will not be enlarged. Thereafter, my lord, the management has taken the plea that the state government has no authority to refer the dispute for adjudication because Steel Authority of India Limited is a government of India undertaking. The Lord Advocate for the workmen submitted that the Honorable Supreme Court in case reported in such and such, in the case of heavy engineering, Mazdoor Union versus.
Where is this order? Order in LP? Right, recording.
So, this issue has already been decided. It has reached its finality.
It says that it will not enlarge the scope of the reference, right? And the scope of the reference was the relief was sought only against the contract.
But my lord,
so maybe that, you see, a party is there to put many things on record. Maybe that Bokaro Steel Plant was required to place the records as to who were the persons who were working, who the contractor. No, therefore the relief could have been granted only for the contractor and not against sale. The LPA court says that the scope will not be enlarged. You just tell us the issues which have been framed by the learned labour court, does it fall from the original terms of reference? No, it doesn't. If the scope is not to be enlarged, then those issues are also bad. The relief would have been granted to you. Where is the contractor? He is a party.
He was a party.
Where is he?
Out of several contractors, only 3 remained, Your Lordship. Other even left.
Left means what? They did not participate?
They did not participate, they have left the work.
You have made them party?
But my lord,
notice has been issued?
No.
You do not know where is your relief lying. दो आदमी का डिस्प्यूट रेफर हुआ, थर्ड पार्टी बन गया नेसेसरी पार्टी, but can any relief be granted against the third party? He could be necessary party for many purposes,
But not beyond the reference.
but not how an order can be passed against a person who
But my lord, our case is not that engagement of those contractors are camouflage, and to that effect, finding is there.
then you should have made the reference against the, you should have sought for reference.
रेफरेंस तो एक बार हो चुका है, उसमें हम
नहीं,
कैसे
fresh reference हुआ ना 97 में. There was a fresh reference in 2000.
fresh reference before the tribunal.
That's right.
Before the tribunal.
That's
First
right.
labor court में हुआ, since the number of workmen were there,
That's right.
more
Therefore,
than
there was a
100.
fresh reference. Then you should have at that stage when you.
Madam, labor court said sale is a necessary party. That order is affirmed in LPA. Also, it has reached its finality. Now, my lord, the tribunal is to see, my lord, in accordance with the pleadings and evidence led by both the parties, whether there is
terms of
empirical.
reference क्या है? Terms of reference is whether the contractor was
My lord,
justified.
scope of reference, my lord, scope of reference is to be also to be seen. My lord, pleadings of the party and evidence adduced by the parties are to be seen. My lord, the finding is there was employer-employee relationship
Between whom?
between sale and my lord the concerned
What
workman.
my reference is at when it starts at page number
But scope of
41.
reference
Where is
for
the
that-
order of
that-
the LPA? Where is the order of the LPA?
ये order ट्राइब्यूनल रिकॉर्ड में होगा, ट्राइब्यूनल रिकॉर्ड में होगा.
Tribunal का तो
What is
record
the
आया.
scope of reference to that effect also, my lord, I will place one judgment of Honorable Supreme Court. What is the scope of reference? My lord, pleadings of the parties and evidence adduced by the parties are relevant to determine the scope of reference.
The reference starts at page number 47.
Order जो order पे इतना rely कर रहे हैं वो order का copy नहीं है.
ट्राइब्यूनल रिकॉर्ड में होगा.
LP number 81 of 2002 down. Order का date है 15/12/2002. बस दोनों में यही पॉइंट है. Both the cases same.
सेकंड में तो हम इम्प्लीमेंटेशन के लिए किए हैं, इसलिए टैग हो गया.
क्या चीज?
सेकंड वाला हम किए हैं, the workman filed the writ application for implementation of the award.
यहाँ से implementation होगा. कौन implement करेगा? Deed में होगा. जब execution फाइल करेगा.
कुछ नहीं कर रहे तो हम फाइल कीजिए. Anyway, जो भी हो.
इसको तो अभी हटा दो. You have a remedy under law. You file your execution case.
But my lord, if facts are not in dispute, my lord, the under Article 226, my
No,
lord,
no,
this,
no. We will not entertain.
if facts are not in
Jurisdictions are
dispute,
necessary.
उसको एक साथ decide किया जाएगा.
नहीं नहीं एक साथ क्या करना.
नहीं, दोनों उम्मीद करके आए हो जो subject matter तो एक ही है.
Not maintainable. हम तो already एक आध order कर दिए हैं. यहाँ से नहीं होगा.
एक judgment उसमें हम लगाए हैं जो kindly have a look to the alternative remedy is not a bar to invoke my lord Article 226. my lord उसी में है.
Discretion है ना court का. You're not
remedies. उसी में annex है.
कब करना है बताइए हम देख लेंगे. कुछ नहीं आपका केस.
हम तो रेडी हैं, हम आज भी करके नहीं थे.
ठीक है. कब करना है बताइए. आपको कब करना है टाइम ही मांगे.
My lord, the concerned workmen are starving, my lord. हम तो ready हैं.
81/2022.
After
2009 से ये केस पेंडिंग है तो मेरे कारण नहीं पेंडिंग.
ना that नहीं बोल रहे हैं.
इतना सारा
हम तो
आइए
ready है.
इसलिए इतना आइए फाइल हुआ.
For payment under section
17B हुआ है.
वो भी डिस्पोजल हुआ था.
All the IEs are disposal.
It is being paid.
हाँ, कुछ लोगों का
कौन दे रहा है पेमेंट?
सेल
और कॉन्ट्रैक्टर को आप पार्टी क्यों नहीं बनाए? Tell us.
No, the finding is that my lord sale is the my lord to reinstate us.
Suppose this court comes to a finding on basis of material. Suppose you do not know what happens. So liability can be fixed on the contractor. Isn't it?
Party before the labor court election. The contractors one. There is not one contractor, but more than one contractor.
Since the finding of the labor code is my lord direction to the my lord Bokaro Steel plant to reinstate.
Suppose this court
So,
comes
my
to a
lord-
finding that the Bokaro steel plant could not have been directed and the relationship what was held by the court is not proved and the relationship was only qua the contractor, तो हम किसको रिलीफ देंगे और कैसे रिलीफ देंगे?
Shall recover करेगा
Those
उससे पर-
persons who are party in the proceedings.
No, my lord, in 17B application it
No,
is
not
not
on
necessary.
17B. We are not bothered about. We are about final disposal of this writ petition.
In sale rate petition, they are parties here, Lordship. They are parties in
In
sale rate
which?
petition. In
WPC 1716.
Lordship.
They are parties.
They are parties.
Notice has been served or notice not issued.
Notice not issued, Your Lordship. Notice not issued.
Notice has never been issued.
My Lord, because on 26th August 2010, my Lord, the Honorable Bench granted stay, my Lord.
So,
And thereafter, my Lord, the IAs were filed and payment was made, my Lord. There was
you served them notice. We can't do anything about it. You have made them party, you served them notice. Notice serve करिए, ऐसे कैसे serve करिए? आप चेक कर लीजिए इसको नोटिस कर लीजिए थ्रू कंसर्न पुलिस स्टेशन कर लीजिए दैट वुड बी बेटर ये सब कॉन्ट्रैक्टर जीवित हैं नहीं है क्या है वी डू नॉट नो कब का 2009 का मैटर है ये छुट्टी के बाद कौन सा बेंच बनेगा क्या बनेगा इट्स वेरी डिफिकल्ट टू सी The records of the case reveal that notice has not been issued to the respondents. तो ये जो भी अपेयर कर रहे हैं सिर्फ वर्कमैन अपेयर कर रहे हैं इन द
first parties workmen and thereafter, my Lord, the contractors.
मैं इसको रिकॉर्ड देख के बताऊंगा ऐसे 4:30 बजे आप सोच लीजिए नोटिस करना चाहिए आपको फाइंड इट आउट ऐसे उसमें बहुत सारा ऑर्डर्स है इतना सारा आइडिया है कौन फाइल किया है नहीं किया है वी डू नॉट नो ऑल द वर्कमेन हैव फाइल्ड देयर इंडिविजुअली
Individual, okay, since they are not gainfully employed.
45 workmen how many workmen were involved
In the
128.
all 128 have not come they are not here
My Lord, 128 are not.
counsel for the parties are present as the court time is over post this case on ट्वेंटी थर्ड आप सोच लीजिए नोटिस करना है नहीं करना है थिंक इट ओवर ठीक है